with our presentations. Our fifth speaker today is Judge Nikki. She hails from Dallas, Texas, where she is currently a mediator and formerly served as a statutory probate judge for Dallas County. Judge DeShazo received her law degree from SMU in Dallas, Texas, and currently serves on the executive board of Dedman School of Law. Judge DeShazo has worked on several groundbreaking cases, is a co-author of the Probate Texas Practice Guide, and has received numerous honors and awards. Today, Judge DeShazo will be presenting common probate errors from a probate judge's perspective. Ladies and gentlemen, I am pleased to introduce to you Judge Nikki DeShazo.
Good morning, because it is still morning. I'm delighted to be here. This is the first talk I've given since I left the bench. Now, I've got to tell you, as I started preparing for it, I thought, wait, I have a problem. By the very title of this talk, I'm supposed to be talking from a probate judge's perspective. I haven't judged in over 3 years. I got to correct that. I haven't been a judge in over 3 years, presiding over a case. I've judged a lot of things since then. When I first retired, I did accept assignments, either to particular cases or I'd sit for a particular judge by the day or a week or whatever time was necessary. But other people's courts weren't my favorite place to be. So I got out of all those cases, extricated myself, and decided I was not going to accept assignments anymore. I started mediating. I love mediation. It gives me so much more flexibility, and I feel like I'm really doing something that's helpful to the parties if we can resolve a case prior to them spending a lot of money and time in the courtroom and coming up with a solution from a judge or jury that doesn't really meet all the needs that they have in that case. So, I'm out of litigation, haven't judged in 3 years, so maybe my perspective is a little bit skewed. In order to buffer that a little bit, I've been talking to and communicating with the statutory probate judges that I know and love. And after reviewing their comments and listening to what they say, you know what? Things haven't changed that much. You guys are still making the same mistakes you used to make. So you've probably heard all this a lot before. You're going to hear some of it again today and maybe some suggestions that might help alleviate some of the problems that the probate judges are seeing. Of course, the big buzz now is e-filing, and you've already heard about that. Dallas County was one of the first places it got rolled out. So we've been hearing a lot of informational presentations. I hear lots of complaints. The judges are concerned that because the clerk has the ability to hold on to that filing for 24 hours and the ability to reject it, that maybe some of the clerks around the state might be practicing law rather than reviewing the format, reviewing the content, and sending it back. I've heard attorneys that complain about the e-filing because they don't know if it's been filed for 24 hours, and that's a problem. And then there's the problem with the wills that have to be transmitted to the court. One judge was telling me that right now, and it's not really a result of the e-filing, this was before e-filing was initiated, at least 3% of the wills filed with the clerk got lost. And I'm afraid that number is going to increase with the e-filing issues. And so are some of the judges. And there's some new service rules because the deadlines have changed. So just be aware of that. And there are seminars being offered in various counties and online. One of the best suggestions is to go ahead and, if it hasn't rolled out in your county, go ahead and choose a service provider that will be the link between you and the court, and start experimenting and using it so that you feel more comfortable when it is mandated in the area where you practice. Okay, and then there's the new Estates Code, and you've heard a lot about that. You know, it's not a substantive change. One judge said it's like they took the probate code pulled it apart and just stuck things a different place. So I'm having to find where they stuck them. But I think we're all becoming more comfortable with it as we learn where it is and what we're looking for. And thank you, Professor Byer, wherever you are, for doing the wonderful job and making that an easy find it from the old to the new. Most of us like the format. It is laid out very well, so I think we're going to adjust. Now, no matter where you practice, whether it's a statutory probate court, a constitutional county court where the county judge actually hears probate, or a county court at law, the estate code's going to be the same. So the differences are going to be the judges, and there are a lot of differences. My suggestion to you, whether you're a new practitioner or you've been practicing for a long time, anytime you're going into a new court, find out what rules there are for that court, find out what the judge's preferences are, go and sit and listen to a hearing, see how the court operates so that you don't feel unfamiliar and uncomfortable when you go in with your first case in front of that judge. I had this gorgeous courtroom. It was built in 1915-16 era, tall ceilings, all the wood carvings, the way a courtroom should look. The acoustics were terrible, absolutely awful. So while in most courts the judge would prefer that you stand to address the court, that was a killer in my court. If you stood to address the court, you weren't in front of the microphone and I couldn't hear you. And a lot of other people couldn't hear you. Now, we could hear everything from the back of the courtroom, so my big, tall, burly bailiff would walk up to them and say, shh. Those are things that you would like to know before you bring your client into a courtroom. So visit the court. Get their rules, because most every judge has some particular rules and suggestions for practice. And they also have some forms they might prefer that you use. If you use their forms, you're home safe. If you follow their rules, they're going to appreciate it. And if you're a new judge, if you're a new attorney, if you're recently licensed or in a new place, why not go in and introduce yourself to the judge? I always enjoyed meeting the brand new attorneys, talking to them for a little while. After they got a little bit of experience, I'd put them on the ad litem list, which is a great thing to be on if you are just starting a practice, or if you're kind of winding down your practice and want to get out of some of the things you've been doing that you don't enjoy. So that way you're more familiar with it. When you bring your client in, your client is going to be more familiar because you're going to be comfortable. And if you prepare your client, then you're going to have a better presentation before the judge. Now then, if you're taking your client into the courtroom, why don't you go ahead and sit with them? Make them feel comfortable. Don't go up and turn in whatever paperwork you need and then walk away and sit in front of the bar. Sit with your client. Make them feel more comfortable. It may be just a routine case for you, a routine prove-up, but to your client, it's the only case they have under most situations. And they would like to know that you're giving it the full attention that they think it deserves, and they'll feel a lot more comfortable. And while you've prepared yourself, make sure you've prepared your client. Make sure that your client knows the questions he or she's going to be asked and are ready with the answers, and that they fully understand the question. Asking someone if they're qualified and not disqualified to serve doesn't really convey the information that you need to convey to the judge. So be prepared, prepare your client, and things will go a lot smoother. Now, at this point, I feel like I could almost sit down and say, after saying, read the estates code, do everything it says to do, make sure your citations are all correct, and that you get all the information to the court. I could just sit down, because if you did that, the list of things I'm going to talk about wouldn't be important. So let's go over some of the common things that probate judges around the state have pointed out to me. Believe it or not, sometimes a pleading has the wrong name for the applicant or the decedent. It has an incorrect date on the will. You know why? Because most of us are a little bit lazy and we pull up the form we used the last time and we black out we take out the name and we put in the new name. And it's just one of those things that happens. But make sure you read everything before you file it with the court. Make sure that you've got all the names, dates, information correctly. Now, the other thing that's a little unique in probate courts is that your testimony needs to be reduced to writing and signed in open court and then signed by the clerk or sometimes the judge. And that's true whether or not that court has a court reporter. It harkens back to the old days when probate courts weren't courts of record. Everything that was done in the probate court could be appealed immediately to the district court. So all of this was written, filed in the case file, because there would be no record produced by a court reporter. They weren't courts of record. That, of course, has changed, but some of the things that we do have not changed. In some courts, the judge will actually sign the proof after the client has testified and signed it. In some courts, the clerk always signs it because that's the way it's always been done. Whatever, make sure that you have your proof, make sure that your client knows what he's going to testify, and that you're ready to do what needs to be done to get your application for probate of will approved. And sometimes those proofs need to be signed in other cases, like determinations of heirship. Some of the other complaints: attorneys aren't ready with Social Security numbers for the personal representatives and the decedent. While you may be able to hide those Social Security numbers from the public, they still need to be available for the judge and for the regular records. If you're doing a determination of heirship, make sure that your testimony is reduced to writing. I just talked about that. Make sure that if you're probating a copy of a will or a codicil, that you obtain waivers from the heirs, because that's easier than serving them and a lot cheaper. You've got to have that. If you have filed the will for probate and then it's lost, it's a lot easier to prove the contents of the will and the reason you can't produce it. Otherwise, you've got to prove those things to the court, that the will was not destroyed by the testator. You've got to explain why you can't produce it, and there are a lot of reasons. And then there's special notices in addition to the regular notices. Notices have to go to those people who would be intestate heirs if the will were not admitted. And you've got to give notice to unknown heirs, and those are publication notices. The court may want to appoint an attorney ad litem to represent anybody who has not the ability to respond. Let's see what else. One suggestion one of the courts had was, if you've got the same people who would be intestate heirs as the people named in the will, then you might want to just get waivers from them and save the cost of serving them. Then I'm trying to skip over some of the things that might have already been covered by some of the previous speakers. Oh, if you are dealing with a case where the will is not capable of being produced, the old rule was, if it's you can't use the self-proving affidavit to prove it was properly executed, so you had to bring the subscribing witness to court, and that's what most courts require. However, if the court or the clerk's office has lost the copy, it's a lot easier to rebut the presumption, and you might not have to bring a subscribing witness to court. In fact, another judge pointed out a case, and I'm going to give you the citation. I apologize, it's not up on the board. And you might want to write this down, because it is a good argument that as long as you've got a photocopy of the will, that's proof that the contents of the missing original. And that citation is 20 Southwest 3rd, 14. It's Bracewell versus Bracewell out of the Court of Appeals in Houston. So you might be able to talk the judge of some courts into accepting that without having to bring a subscribing witness. Okay, wills offered after the 4-year statute of limitations. If you're offering a will outside that 4-year statute, you're going to have to give notice to heirs, and the court's going to appoint an ad litem for the unknown heirs that have also been noticed. You're going to have to reduce this testimony to writing again. You should also make sure that your order that you present at the time you're proving up your case is an order admitting a copy of will, not the original will. See, they're all little picky things. If you'd read the code, and I'll bet that most of the people in this room don't make these mistakes, but you can pass this along to somebody who has or might. Okay. Make sure that you've got appointments of a resident agent for any out-of-state personal representative. Make sure that the application states whether or not the will contains gifts to the state or charitable bequests. Make sure that you either have waivers and consents from all the, well, you must have waivers and consents from all the distributees if you are seeking a court-created independent administration. That is a wonderful way to avoid some of the problems of dependent administration, the increased supervision by the court, the increased necessity to file accountings and a final account. If you can get all of the distributees under the will or all the heirs at law to come in and request an independent administration. You can also ask the court to waive bond, but that again, you must have waivers and consents from all the distributees. A little different under the new estates code, and probably the last iteration of the probate code, is the fact that you don't have to report every divorce that a decedent ever had, just those divorces that occurred after the date of the will. Let's see. Oh, be sure that you list the names of witnesses to wills and or codicils, no longer their addresses. Don't have to do that. And some judges will require that you file an entry of appearance if there is a co-executor named in the will that is not an applicant. If the will names co-executors, then either file a declination from the one who isn't going to serve, or if you in fact do represent all of the co-executors named in the will, make all of them applicants so the court's not wondering why somebody isn't there and why, since they're named in the will, they haven't got an entry of appearance. Let's talk a little bit about guardianship issues because there's some of the other complaints that are heard. In some place I know there's a timer here, but I'm not sure where it is. If you are considering filing a guardianship for your client because someone is incapacitated or minor, ask yourself, first of all, is the guardianship necessary? Because there are other opportunities to take care of the problem presented without going into a full guardianship. If the amount in controversy is $100,000 or less, you can use Chapter 1351. See, Bill, I did look up a few of the new numbers. And you can take care of payment of claims without a guardianship, or you can take care of a parent's sale of minor's property, or deal with mortgage property and a homestead interest without having to have a guardianship. Those things can be taken care of outside a guardianship. Now, if you do go forward with a guardianship, some judges have suggested that it's a good idea to plead everything that you could get. Ask for a guardianship of the person, a temporary guardianship of the person, a guardianship of the estate, and a temporary guardianship of the estate, even though you don't think you need any of those. Now, it's the court's job to pare that down and craft a guardianship that meets the needs presented, but so that they can get in touch with that attorney if they need to. And they actually want an order that approves the annual account so the judge can sign it without having to call or have someone from his staff call to get that order. Application to pay commissions or attorney's fees must be accompanied by a fee order. Those things sound so simple, and yet they're problems in some courts, so be aware of that. And the final account in guardianships. If your ward dies and there is a will, then you've got to file the will for probate, make sure that you get letters testamentary, and then have the executor file a waiver of service before the final account will be approved by the court. If the ward dies without a will and there's no need for administration, you might want to go ahead and in the guardianship apply to pay any funeral expenses if there hasn't been a pre-need burial plan already arranged in the guardianship or by the ward prior to the guardianship. And then you can also apply to pay taxes or expenses, and then any assets that remain could be distributed after a determination of heirship in that same cause number if there are enough funds to warrant it, or maybe affidavits of heirship in limited situations. And then once those heirs are determined, they're going to file waivers on the final account, and it can be approved. Let's see. Any attorney's fees. Now, this is important when we're talking about attorney's fees for attorneys. These are important things you want to pay attention to. All the attorney's fees, all the ad litem fees, anything like that, any miscellaneous application should be approved in a guardianship prior to the court signing the order that approves the accounting and closes the guardianship. Then you've got this 30-day window where this is not yet a final order, but after that time the court cannot sign any orders. So you want to make sure that if you've got fees outstanding, you get those approved and paid prior to the approval of the final account. Otherwise, after the 30-day period, you might have to file a bill of review. And then court-created independent administrations. These are very helpful in situations where all the family members, all the heirs at law are willing to ask the court to create an independent administration, thereby availing all those benefits of independent administration versus dependent administrations, which I would describe as a mother, may I do something every time you want something done. So if you're going to do that, go ahead and, well, make sure that you get all those waivers up front so that you know you're going to be able to get what you're asking for. And plead it under 140. Oh, if I didn't look up that one, you're going to have to use the reverse and find out what 145C now is called. One of the reasons this is becoming more and more a problem, the need to ask for court-created independence, is because of all those do-it-yourself wills out there that people are using. You know, internet is great. You can find all sorts of things. And in fact, Ed and I were driving the other day, and on the radio we heard a radio ad. They're going beyond just wills. There's now a limited liability corporation kit that you can order and pay for. I think it was $29.99. Of course, they did do the disclaimer. There are no attorneys that are going to give you any information whatsoever. So look forward to that, too. Okay, posted citation is required on all motions to abandon estate property, either in an administration or a guardianship estate. If you're going to file an application, and I'm just going over this checklist, guys, for partition and distribution pursuant to new section 360.001 or 2 for partial, there's got to be posted citation posted by the clerk, personal citation to all unknown heirs, all known heirs within the state, and waivers. The attorney can obtain a setting, but you need to get that setting before the posted citation is done, because it's got to be included in the posted citation and any personal citation. So you file it, then you get your hearing, then you have the service issued. Some courts are now requiring that reports of sale be accompanied by a letter of appraisal from a real estate agent concerning the value of the property. And at least one judge is concerned that the problem with disclaimers is back. The problem he's talking about is the fact that if you disclaim thinking it's going to go back to mom, but you have children, it goes to your children and creates an even bigger problem. So make sure that if you prepare a disclaimer, you know what's going to happen when that disclaimer becomes effective, because you can't back out of it. Oh, attorney's fees. I told you this is important, and of course I want to make sure that this is our last point. One judge observed that he's amazed that when an appointed attorney comes in and it's a final hearing and you know the judge is going to set the fees, that attorney's not ready to give that testimony and doesn't bring the court his file because it's just too voluminous. Take care of yourself and make sure that your attorney's fees are addressed by the court timely and you get what you have earned, and make sure that it is reasonable under the circumstances. Okay. I want to talk just the last 2 minutes I've got to the new attorneys or the prospectively new attorneys in the audience. Mentoring is a great process. Find a mentor. Dallas Bar Association has a mentoring program, and if there's not one here, you probably should talk to the Bar Association about doing it. Another thing that I want to encourage you to do is join the Reptile section. You've heard a lot about the work that the Reptile section does. You haven't heard about the benefits to you as a practitioner. If you are within the first 5 years of your practice, you get discounts on anything that the Reptile section co-sponsors, put on by the State Bar. That's $25 off of your registration fee in any of the things they are participating in. And if you go to 2, you've already paid for your section dues for the year. The other thing it provides is an incredibly large database where you can research and find prior papers that have been prepared for and presented at CLEs across the state. That's worth a whole lot. So please join the local bar. You have to be a member of the State Bar. Join Reptile and participate so that you not only have the benefits of just being a member, but you have the benefits of actually helping shape the law in the state of Texas. Thank you very much.